Hey everybody, how are y'all doing? Welcome to American Courts. Judge Fleischer said I needed a catchphrase today, and Linus is still working on it, trying to figure out what my catchphrase is. How's everyone doing? I see we got LD's here, Jay's here, Linus is here. To get started, we're going to put our Discord links and Linktree links all at the beginning. We pinned it, so it should be there for everybody. Let's look and see what all we got in the comments here. Roll on Green, thank you for showing up. Jasmine, hey, how are you doing today, Jasmine? Sivo girl, it's always great to see you. Always great to see you there. It's the 7th. Yep, thank you so much. Hey, Sean, good to see you here. There's I'm going to guess at Imagine. Good to see you here. Good to see you here. We're going to start off with Judge Fleischer. Judge Fleischer's always interesting. He had a couple of neat ones today. I didn't get to see a lot of it, but I'm going to show it. And then we've got some Judge Webster doing some traffic court. Here we go with Judge Fleischer.
I'll stand right here. Yes, sir.
Now, in life, Mr. Stevens, there's almost always a reason for things. It doesn't happen just for nothing. You failed to take a drug test when I ordered you to do it. So I had you come here and I sent you for a drug test. What did you test positive for? Right. You tested positive for cocaine. So I'm now going to revoke your bond and I'm keeping you with me. It goes with you. We will, I guess, speak about where we go next.
I'll see what I can judge it, but we'll work it out.
The bond is set at now 2501 because he's already failed to appear one time before this. I'm going to now set it at 5002. And then if he gets out, if he's able to bond out, which, because I don't know, I mean, perhaps you can get a hold of the family and see if they're able to bond him out. If not,
Work it out.
yeah, we'll see where we go from here. Okay.
And I believe you said to take a drug test.
Tested positive for benzos. What?
I don't know, I believe he's charged with possession of benzos.
Yeah, you know, let me, Mr. Elick, can I do this play real quick? Give me, because yours is going to be a deeper dive. This doesn't help you.
All right, y'all win. Hi to the mods. We've got some good mods. I tend to overlook them because there's so many blue wrenches out there, but hey to the mods. Hey, Sharon. Hey, hey, Cynthia Johnson. But definitely hi to the mods. The mods do a real good job. They put in a lot of work, and they do a lot of after-hour stuff. I never imagined that there'd be so much after-hour stuff, but they do a lot of that. But hey to them. Just to give everybody a heads up, I'm getting warnings saying that my YouTube's not receiving enough video to maintain smooth streaming. So if y'all see any glitches or anything, let me know, and just be patient because it's the same internet as it is every day. So who knows? But thank you guys for coming out, and let's see what the show's got.
This doesn't help you. This only hurts you. You know, you testing positive for cocaine. Now you go into custody. Now you're just going to plead guilty. You're going to walk out of here. You think this is going to help? Something's got to give at some point. How old are you?
46.
You're 46 and you're using. What do you think? You're 18? Your body is not going to take it for much longer. Something is going to give. Do you understand? So unless you want to be in an early grave, I would be very careful because you don't have the body of an 18-year-old. And at nearly 50 years old, if you're still using cocaine, you're not going to be with us much longer. Either that, or you'll end up in prison, which would probably save your life anyways. With your driving record, now what you're doing is you're pleading guilty to this DWI, Mr. Stevens. And as far as I can see, with regards to your criminal history, from 12, no driver's license, another 12, speeding, 13, driving while your license is suspended, 15, driving while your license is suspended, now a DWI. When you get pulled over, what do you think an officer is going to do to you? They're going to harass the heck out of you every single time just because of your record. So if you have the faintest smell of alcohol, the smallest amount of dope, you're going to be right back over here. What we're doing today will not happen again. From now on, you're facing a minimum of 30 days in jail. Do you understand? So if you ever get behind the wheel, I wouldn't unless you have a license and insurance, because you are guaranteed a jail sentence anytime you get in the car, if at the minimum you don't have those things. Do you understand? You're giving up the right to a trial, right to compel witnesses testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never undo this. You're pleading guilty. This will go on your record. And it's just another notch on your record to give officers a reason to harass you when they pull you over. Do you understand? How do you plead to the offense of driving while intoxicated? We'll find you guilty. Hey, guys, what are we doing? 3-1. 3 days in jail. Credit for the 1 day that you've done. I'm going to suspend your license for 180 days, sir. Do not drive until you get a license. Otherwise, you're going to be back here. And I'm telling you, it's not going to go easy for you. Do you understand, Mr. Stevens? Good luck, sir. Thanks. Thanks, Ron, for coming.
Mr. Stevens,
Abandon the enhancement.
Mr. Stevens.
He face planted, to be quite honest. So he knows what's about to happen. And I'm not going to try and defend the
He knows,
indefensible.
and he knows.
Yeah.
I mean, but I don't know what happened. That's what I want to find out. Mr. Wiggins, how's jail? How's jail? Is it good? All right. All I know is that we've got you on an assault of a family member, right? All we ask you to do is be good, right? It's fine. It's not a big deal. You know, I see that you've picked up an aggravated assault with a deadly weapon, violation of a bond condition or assault, stalking, another aggravated assault of a family member, and then another aggravated assault with a deadly weapon. So you picked up 1, 2, 3, 4 aggravated assaults, and then another felony violation of a bond condition. I don't know what happened. So I'd like to know, because, you know, I need to make sure that Harris County is protected as well. And it seems to me that it may be an issue. So please, what happened?
First, I'd like to question now that DVD filed a motion to revoke and raise. They're asking for $100,000 bond because of the sheer amount of violations
Okay,
and the injury to the complainant and threat to the complainant and the safety of the community. On the newest, on the ag assault ending in 500. August 5th, 2024, deputies responded to an ag assault call. It started as a call for speeding. Both the affiant and the sergeant, his sergeant, observed a gunshot in the back window of a white vehicle. The affiant met with all 3 complaining witnesses that were inside the white vehicle. All the victims are minors. Complainant JT stated that they were at DT's house. Complainant JT stated that he observed the defendant drive off in a gray car, and she observed the offender get out of the driver's side of the car, load a black pistol, pointed the pistol at the complainant's inside of the vehicle. Complainant JT then stated she attempted to flee the area and had complainant AM in the right front passenger and DT in the back seat. JT, the driver, stated she sped off and the offender fired 1 shot at the white vehicle as they were speeding.
so he fires off a shot to the vehicle.
Right, yes, Your Honor. She stated that she was speeding above the speed limit because she and all of the other complainants were in fear of their lives and believed the offender wanted to kill them. She stated that they were trying to get away from the offender and the offender was following them in his vehicle. And she said the offender left the location, got out of his, she had stated that when the offender left the location and got out of his vehicle, she realized she was grazed by the bullet in her upper right arm that was shot through the car. The officer observed the injury to the complainant.
Oh, so she was shot in the arm.
Sure.
Raised, it wasn't direct hit, it was a slight.
She's 17 years old, Your Honor.
And that is,
The same complaining witness is in our case.
was the driver
Oh,
of the,
I guess should be lucky that she's not dead, because probably, 3 inches to the right. Could have been the head, could have been the heart, and you'd be looking at a capital murder charge. Life without parole.
the VPO stems out of the same transaction. The other ag assault actually predates all of the newest ag assault is from 2023. We can read that one too,
Okay,
if you wish.
Okay. On October 15th, 2023, the complainant's officers, or the complainant's mother, Miss Alexander, stated that on October 15th, 2023, a defendant was passing by a Jack in the Box, decided to stop there. The complainant stated as he was walking through the front doors, the defendant approached him with a brick in his hand, and the defendant threw the brick towards his head and moved quick. And he moved his head quickly to one side, causing the brick to hit him in the left shoulder and left bicep. The complainant in this case is DT, the brother of JT. Okay. Is that or not?
I don't understand what anger. I'm not asking you whether you did or not. I don't really. But I don't understand what anger would cause someone to do such things that where you would be living in a 6x9 box for the next 5 to 7 years, I'm going to find, Mr. Wiggins, that you are an extreme danger to the community. And I'm going to set your bond at $250,000. If you do bond out, you will be required to have a GPS monitor. You will be required to be under home confinement, not to have contact with any of the complaining witnesses in our case. Do you understand, Mr. Wiggins? We're lucky that it's only a graze, because it could have been a lot worse. And I just, there's always two sides to a story. I get it, right? And there's always video, there's always some kind of evidence out there, and we'll get it. The problem is that the allegations are pretty bad, and there are witnesses that put you there, and not just one. But how many people in the car? 3?
3, Your Honor.
3, that's why there's 3 separate charges.
So like I said, if you want to stay on, let me know.
Yes,
If
Your Honor.
not, you tell me what date you want to set it for. Looks like the felony court set for 9/24.
Yeah,
I'm at your mercy.
regarding this, Judge, can I have a week from today?
Absolutely. So
Hey, everybody. Just want to thank everybody for coming in on the Biggin raid. Thank you so much, Biggin. Really appreciate you coming over here and bringing a pile of people with you. Thank you so much. Our Myco Psycho, he says, hello all, I'm bringing some friends. Wonderful. Well, we've got Donald over here waiting on you. Nan's here. Looks like we got the crowd over here. Fozzie had to work tonight, so he didn't get to come by and play. Hey, KK. I know I'm going to miss everybody. Miss a bunch of people here. Chris Barton, see some familiar names. Yep. Thank you for coming over. We've got KS, Calamity Jane. La Darby Romeo. Where am I? You're at American Courts. Thank you for coming over here. We're going to get back to Judge Fleischer, and then after Judge Fleischer, we've got some Judge Webster out of Kansas. She's always fun. we're going to jump back in.
They're hired onto your case now. I don't know if they're gonna want to stay on your case because it's a lot of baggage, right? And it's a lot. So if they want to stay on your case, we're happy and welcome to have you on the case. If not, they're gonna withdraw and then I will appoint you a lawyer. We're gonna decide on that in about a week so I can give them enough time to talk to your family to see if that's something that, you know, if they want to hire them on your other cases as well. Okay? Okay, man. Good luck.
All right, Judge.
So
Good
200.
excuse.
Yes, sir.
Thank you.
Thanks. 200.
Speak up pretty loud.
Okay.
Jared Regier, again appearing for the state.
Thank you, everybody, for coming out again. This one here, Judge Webster does some traffic court. This lady's here is about 10 minutes, and then the next one's coming up for about 25, 35 minutes. I'm trying to finish editing a good magistrate one from today. Today was like every other day. It runs a little bit too busy. I've got a dog that needs more attention than she wants, or wants to let me know she needs. She's a good dog, but she wants me to watch her go eat, and I'm not willing to do all that. So, but she tried to give me a run for it. My wife was out of the house, and so she needed the attention, so it distracted me some. But here we go with Judge Webster.
Leah January, the defendant, appearing in person and pro se. This matter does come on for bench trial. The defendant originally had 3 charges, but count 3 was dismissed June 27, 24 by the state, that charge being reckless driving. So we're set for trial on count 1, speeding 76 and a 65, and count 2, failing to yield to an emergency vehicle. And Ms. January, are you still wishing to proceed with trial today?
Yes, I have a question about the, when I got the amendment where they dropped the reckless driving, that made me very happy. But
Sure.
the second count, the
Failure to yield?
8-1558, right? I was actually charged with B 1558. Is that what it is? No, that's the wrong one. I'm sorry. 8-1530B, which is failure to give room to a emergency vehicle. I don't know. I know they're basically the same thing, but it wasn't like I didn't, you know, it was just a different charge that I actually had on my ticket.
Let's look. You've got in front of you the citation, it sounds like.
Yes, yes.
That does charge failure to yield under 8-1530B.
Right.
And that's what the officer cited you for. Now, when the ticket goes to the county attorney or his assistant in this case has the responsibility of formally charging the case. And it doesn't look like in count 2, they specified the subsection.
Right.
So are we in a position where you would admit one subsection but not the other? Did I misunderstand?
Well, yeah, the thing is that it was a 2-lane highway and I'm not.
Let's not get into your defense. Let me do that.
Okay, I'm sorry.
That's all right. Mr. Regier, is there a particular section you're applying to this case?
Your Honor, in reviewing the amended information that was filed with the court in July of 2024, it does appear to dismiss count 3 while retaining counts 1 and 2, speeding 76 miles per hour, where the legal max limit was 65 miles per hour under case 8-1558. At trial, the state would be prepared to specify the particularized subsection within the speeding statute. Same thing with count 2, failure to yield to authorized emergency vehicle under case 8-1530. I would tell the court that at this juncture, the state would be prepared to dismiss count 1, the speeding, in exchange for a plea to the failure to yield to authorized emergency vehicle. Of course, I don't normally do this, but beyond that, the state is prepared to proceed to trial on both accounts.
All right. Well, there you have him willing to dismiss not only count 3, but count 1 prior to trial if you want to plead guilty or no contest to failure to yield to an authorized emergency vehicle. Now, I added that guilty or no contest. Does it make a difference to you which one she pleads to, Mr. Regier, in this offer?
Your Honor, the state does not take a position one way or another insofar as a no contest or a guilty plea is concerned, although there is, of course, a third type of plea, an Alford plea, but I do not believe this court has been traditionally very receptive to such pleas.
I have no problem with Alfred, please, but I'm just not hearing any indication that that's what she wants to do. We're getting pretty technical here in the legal realm, Miss January, so let's break this down.
Okay.
He's saying that if you plead either guilty, admitting to count 2, the failure to yield, or if you plead no contest, that is, you don't admit the charge, but you don't want to deny it and take it to trial either,
Right.
you'd still be found guilty, but the documents would show that you pled no contest as opposed to admitting it.
Yes.
Now, when he says an Alfred plea, there is that plea that sometimes defendants want to plead guilty to take advantage of a plea agreement, but they're not really pleading guilty because they want to admit it or that they feel guilty. They just want to take advantage of the plea agreement. And that's what the Alfred plea is.
All right. Okay. That sounds really good to me. The only problem, I don't have a problem with it really. And the thing is that when I read, and don't know anything about it, but when I read the 2 statutes, the 1530 and then the 1530B, the B
Right.
is actually worded differently.
They are a little different, you're right.
Yeah.
And the way the
And-
officer wrote it, I believe, is the B that you're talking about.
Right. I would be happy I would plead guilty to that. If the speeding ticket was dismissed, but I would want it to be to that charge that the 1530B.
Okay. And that's Mr. Regier, how does this say? I'm not usually involved in your plea agreements, and I don't want to be,
Sorry.
but you are trying to resolve this in a fashion that I'm okay with, Mr. Regier.
Your Honor, if the court is prepared to accept a plea, the state would be prepared to orally amend count 2 to KSA 8-1530 subsection B2.
Okay, so there's what he's offering. Do you accept that? Or do you
Yes,
want to
yes.
go to trial? No one's trying to talk you out of your trial.
No, I don't need to go to trial.
Okay, we have subpoenaed for your trial Trooper B.A. Herber. Trooper Herber, you're with us? There you are. He's ready to go for trial, but you're saying you don't need to go to trial. You'll plead to the charge that he cited you for in count 2?
Yes.
All right, so you're pleading in which plea? Guilty? No contest?
Guilty.
You're pleading guilty. You admit that you did fail to yield to an authorized emergency vehicle?
I admit that I didn't move over to give him room. Yes.
All right, so he was on the side of the road doing
Right.
official business as a
Right.
trooper, and you didn't pull
And I
over?
stayed right in my lane. I did not move over and give him room. So I'm guilty of that.
Hey, everybody, I'm going to jump in real quick. Nan, you asked if Mr. Regier ever smiled. Anyone see that? No, I've never seen him smile. I have seen him be on at least 3 streams at the same time. And he's got his cousin, Canfield, who they look like they're family with each other. I've seen them in the same, or I've seen them on different courts at different times. And so you can watch, while you're watching him, you can see that he's looking at a couple different screens. So they run a pretty efficient office. It's fairly rare that you see them not having the right evidence. Every once in a while they do, though. They slip up. I've seen that one slip up a few times, but he keeps it professional all the time. There's certainly no first name basis. I don't know that he has a first name. I know it says Dan Regier, but or Jared Regier. I'm fairly certain that if someone called him Jared, he'd just stop. So we're going to jump back.
And at this time, can you tell me, were you on the Kansas Turnpike when this happened?
No, I was on Highway 77 between El Dorado and Burns.
Oh, okay. Was that a 2-lane or a 4-lane? That's 2-lane?
It's a 2-lane, yes.
And you didn't slow down to?
I had just passed a car. I made a bad decision. I was going around a car before I even saw the officer's car parked up ahead, having somebody pulled over. And I should have just got back behind that car, but I was already even with him, and I made the wrong decision to go ahead and pass him. And when I did, I was over the speed limit when I passed him. And I don't know if the vehicle in the other lane was actually coming, made it so I couldn't move over. I was just looking right in my lane, and I knew he wasn't standing on the road because I didn't see him on the road. And I think he was in his car. I don't know, but he wasn't on the side of the road. And I felt so bad about it because I know that that's a really dangerous thing to do. And I was really sorry, but it wasn't purposeful. I made the wrong decision. I should have just got back behind that car instead of thinking, oh, I can just get around him. I just didn't. Yeah.
So not only did you not reduce the speed, but you were actually accelerating to get around.
No, I wasn't accelerating. I had just gotten off the gas. I didn't put on my brake. I didn't put on my brake. Yeah. I wasn't accelerating. No, I just hadn't gotten off I just took up my foot off the gas, but I didn't put it on the brake.
Okay, so you went by him at a non-reduced speed, and it was a 2-lane highway.
Mhm.
Okay, well, I am going to accept your plea. Is anyone making you enter it today?
Anyone in what?
Is anyone forcing you to enter this?
Oh,
plea
no,
today?
no, not at all.
All right, so you're pleading guilty because you think you were guilty. You did meet the definition of the crime. Or
Yes.
the infraction. All right, I'll accept your plea as freely and knowingly given. You know what you're doing, and you're doing it voluntarily. I will find you guilty of count 2 and dismiss the remaining count of speeding. Motion of the state. And I believe counsel, that's 198. Am I remembering that correctly?
One moment, Your Honor.
Let's see, that is 195.
And that is the state's understanding as well, Your Honor, pursuant to KSA 82118 subsection C. I am also showing that in this matter, it would appear that a written waiver of counsel had previously been executed, signed by Your Honor, and filed with the court back in June. For purposes of the journal entry from today's hearing, the state would respectfully request clarification as to whether that is continuing, and if I have leave to journalize that in the journal entry from today's hearing. Beyond that, the state does not object to the imposition of the scheduled fine and court costs, while deferring to the court, of course, on the issue of repayment of the case.
You may journalize that waiver, although this particular charge does not have any jail time, so she really doesn't have to waive that. She has the right to hire an attorney, but not to have one appointed. But it doesn't, since she did sign the waiver, it certainly doesn't hurt to put that in the journal entry.
Thank you, Your Honor.
You're welcome. So, Ms. January, the fine is $195. The court costs are $108. The total due is $303. And do you need any time to pay that, or can you pay that today?
I think I can pay that today if the court will take a credit card. Do you do that?
Let me ask our clerk. Destiny,
Okay.
can you take your credit card here at the courthouse?
We do. There is a service fee charge that goes along with it, but that can be discussed with the clerks.
Okay. All right. So the answer is yes, that you can pay with a credit card. And you can pay that today just down the hall behind the metal detectors is the clerk's office.
All right.
And I think that's about it. Anything further, Mr. Regier?
Your Honor, 2 points. First, I would like to thank Trooper Herbert for his appearance here today. Secondly, if If indeed it is the court's order that the case be paid in full today, I'm not sure if the journal entry should reflect that or not, and the state would be requesting clarification on that point as well.
The journal entry should reflect that she is to pay today. And because she's paying in person at the courthouse, I understand we do not have to have the journal entry on file.
Thank you, Your Honor.
You're welcome. Correct me if I'm wrong on that, but I think that's the way it works.
Yes, Judge, it'll go into an unapplied account for now, but it'll still show on her case the day that she paid and the amount that she paid.
Very good. All right, so Miss January, you're excused. Yes, Deputy or Trooper Herbert, thank you for honoring your subpoena and being here today. And you're excused unless you have another case on the docket.
I do not, Your Honor. Thank you. Have a good day, and you as well, Mr. Regier.
Thank you, Officer Herbert.
Thank you, Ms. January. You have a good day as well.
All right.
Well, then let's move on to our next
Okay. I'm out of
case.
here.
All right.
Okay, thank you.
You're welcome. Now we have 2023 TR 2837 on the record for Denisha Sue Kanaji. How do you pronounce that, please?
Kanaji.
Kanaji, okay. So, Mr. Jared Regier for the state, the defendant, Ms. Kanaji, in person and pro se. And we are here for another bench trial. This is for the sole count of speeding 81 and a 65. And Ms. Kanaji, the trooper, is present, and it looks like we're ready to go. Is the state prepared to proceed?
Yes, Your Honor. At this point, for purposes of clarifying the record, the state would be requesting the court make the ruling as to the issue of counsel, notwithstanding the fact that this is a case involving an infraction, as I understand it. Additionally, I would note for purposes of the record that I am not sure if the issue of diversion was discussed at the previous hearing, nor do I appear to be in receipt of any applications for such diversion. As the court is well aware, it is a pretrial diversion, which does appear to be the purpose.
Hey everybody, this one's interesting, but it doesn't give you the ending of it. Judge Webster takes it off YouTube because it's giving registered names and stuff. But it's good to see her arguments. It's good to see her arguments and how she presents her case, and so it's an interesting one. But just giving you a heads up, it does not end. But I think you can all see how quick it's going to end. But here we go.
Of today's hearing.
All right, Ms. Kanaji, when you were here June 5th, 2024, I asked you if for some reason there was a discussion about court-appointed attorney, and we talked about you sending your contact to the clerk's office to get an application, but this is not a case in which you would be entitled to a court-appointed attorney. In fact, I can't appoint one for speeding, so I'm not sure what that was about. But you do have the right to hire an attorney. Did you wish to hire an attorney?
No, but I was not told that I needed an attorney.
You don't need one. You're welcome to represent yourself just as you're doing. So the other question is, we probably talked about diversion, where if you pay for your fines and costs and pay a diversion fee, the state may dismiss your case.
I don't recall that either.
All right, well, that is an option depending on what your history is, and it looks like you're within their speed guidelines.
Well, what I do recall last time was that because I was telling you that it wasn't me.
All right, there you go.
And then you said
that's
something
right.
about time court because I live in Oklahoma, bringing any evidence, and then you gave me a number, 316-322-4555. 4370 to call and no one picked up. And then also I got a email address to send items, but I didn't get a response.
Okay. Is that 437 one of your numbers, Destiny?
The 4370 is, Judge, and I believe I emailed the defendant twice. One was that court-appointed attorney, as it was the order at the time, but I never got a response on that email. And then the other one was for her Zoom codes for today.
Yes, ma'am. That same day, I thank you for that. It was two emails on that same day that I received. And then probably 2 weeks later, I did my time card and then also my bank statement because, I make a lot of do a lot of banking or whatever. And it was showed you that I was in Oklahoma at that time.
Okay, I do remember now. For some reason that part of the notes aren't showing, but I remember it that we did set it for trial. So because we talked about the state would have to be able to prove it was you or you wouldn't be convicted.
Yes, ma'am.
So that's why we're set for trial, is because you don't believe you were the one stopped?
No, ma'am. No, ma'am.
All right. Did you contact Mr. Regier or Mr. Cartwright, either one, to tell him that you thought you'd been impersonated?
No, I do not have neither one of their numbers. I just had that 430770 number, and then I had the email.
Okay. All right. Well, Mr. Regier, I believe, let me see if that was you present.
I believe so.
Yes, it was you, Mr. Regier. Do you remember the conversation that was had in court that day? And if you do you know if there was any follow-up on her allegations, or do you want to just go right into trial and not address that?
Your Honor, the note, based off of the notes that I have, it would appear that the defendant did raise certain allegations at the previous hearing. It looks like the court did address the issue of certain filings that the defendant would make. As in my role as prosecutor, I do not represent her in these proceedings. The state's understanding is that there have been no additional filings with the court other than the original citation, as well as the subpoenas issued by my office and the return on the same. So in the absence of any evidence to the contrary, the state is prepared to proceed to trial.
Hey, Chris, good call on that. She did have quite a good soft sit in there. I wasn't able to catch it, but people in court, if you go to her channel, she's got the video up on there. It was a good one. I'm sure Law Talk with Mike got it, and maybe a few of the other ones, but I know people in court got it. She did a good little video on it, but it was quite a guy on there, and he buried himself. And I'm just thinking about it. Was that guy a soft sit? The one guy the one guy that was in the vehicle that talked himself into jail? There may have been two good ones on there today. So it's worth it to catch some Judge Webster today. She had a good day. So all right, here we go.
Are you going to be presenting any kind of video of the stop or anything like that, Mr. Regier?
Your Honor, the state has subpoenaed Trooper Cartwright, and he will be the sole witness for purposes of today's hearing.
So does that mean you will or will not be offering any video evidence?
Your Honor, at this time, the state does not intend to present any video exhibits.
All right, very well. Well, Ms. Clark, they're ready to go to trial. The burden's on them. You said you had some documents. Typically, well, are you ready to go to trial, Miss? I've said Miss Clark. Apparently you go by Clark now.
Well, I always went by Clark. Well, oh my God. I'm so sorry, Judge. I am so sorry.
So who is Kanaji? Who is
It's
Denise?
oh my God, yeah. It's been this long, hard deal. I just got married and I'm in the midst of changing over the last name. So
Okay,
I'm,
so
I'm
you,
so sorry. So sorry.
okay. Well, I'll try not to use them interchangeably. We typically go by what is on the charging document. Okay, so are there any opening statements?
Your Honor, the state would waive opening statements at this time.
All right. Ms. Kanaji, opening statement as to what you think the evidence would show. You are welcome to make that statement or wait for your testimony.
I will wait.
Okay. Then, Mr. Regier, you may call your first witness.
Yes, Your Honor, the state calls Trooper Brian Cartwright to the stand.
Okay, Trooper, would you please raise your right hand? Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Please proceed.
Thank you, Your Honor. Would you please state your name for the record?
Brian Cartwright.
And where are you employed?
I'm employed by the Kansas Highway Patrol here in Kansas.
And what is your professional title in that capacity?
I'm currently a master trooper.
Okay. And how long have you worked as an officer?
I've been a certified law enforcement officer in Kansas since 2016. I've been with the Highway Patrol since 2019.
So approximately 8 years overall?
Correct.
Okay. Were you on active duty in your professional capacity on August 22nd, 2023 at approximately 3:35 p.m.?
I was.
And where were you at that time?
Would have been on US 400 east of Leon.
And US 400 east of Leon, were you still in Butler County?
Correct.
Okay. And were you in a vehicle or on foot when you say you were patrolling?
I was in a vehicle.
Okay. Do you recall if you were moving or stationary at the time?
I believe I would have been moving.
Okay. And do you recall which direction you were headed?
According to my notes, I would have been westbound.
Okay. So where you were at, if we could focus on that for a moment, could you please describe your general surroundings for the court as you recall them?
Yes, U400 in that area is a 2-lane highway. There are a few houses in the area. It's not super populated, pretty rural.
So besides a generally rural area, as appears to be your testimony today, and the 2-lane highway, would you describe U400 at this location as curving generally or more of a straight shot?
At milepost 308, which I believe is where this occurred, it's a straight shot.
Do you recall if there are any trees nearby in this location?
Not any in that particular area.
Okay.
That are anywhere near the road.
Are you familiar with KSA 8-1558?
Yes.
And what does that say about drivers and maximum speed limits?
It says something to the effect of the posted maximum speed limit is the maximum speed limit. Anything in excess of that is a violation of that statute.
And are operators of motor vehicles required to abide by these maximum speed limits?
Yes.
Okay. Your Honor, at this time, I respectfully request the court take judicial notice of KSA 8-1558.
So taken.
Master Trooper, do you consider yourself capable of identifying traffic violations when you see them?
Yes.
Besides your approximately 8 years of experience, do you have any recurring special training and on an annual basis, or maybe at the beginning of your career, which allows you to identify traffic violations?
Yes, I've been through 2 police academies. One was the Kansas Law Enforcement Training Center Academy, which was 14 weeks. And then I also went through the Kansas Highway Patrol Training Academy, which when I went through was 24 weeks.
Okay. On the date and time we've been talking about, August 22nd, 2023 at approximately 3:35 p.m., did you personally see any acts that you consider traffic violations?
Yes, I observed I believe it was a 2020 Nissan Altima traveling eastbound, appeared to be traveling at a high rate of speed.
Okay. Did you ever see this Nissan pass your vehicle?
It was going the opposite direction of me, so it did pass my vehicle.
Okay. When you say the Nissan passed your vehicle, how close would you say?
It was in the opposite lane, going eastbound. I was westbound.
Okay.
So as far as those two lanes are separated.
Okay. Do you recall if there were any other vehicles nearby when this passing took place?
According to my notes, there were two vehicles in front of this vehicle that this vehicle was catching up to.
Okay. And when you say in front of, where were these other two vehicles compared to the Nissan?
They were also eastbound, just further to the east of that vehicle.
Okay. When the Nissan passed your patrol vehicle, were there any vehicles between you and the Nissan?
Like in the center line?
Yes.
No.
Okay. Besides your own senses, did you use any specialized equipment to check the Nissan speed?
Yes, I used our Stalker DSR 2X radar.
Okay. And are you certified to use this equipment?
I am.
Okay. Do you use testing on it to check that it's working properly?
I do. At the beginning of my shift, at the time, we were doing the internal circuitry test as well as a tuning fork test. Both of them tested accurately. And at the end of my shift, I did the same.
Okay. And this testing at the beginning of your shift, to use your words, how often does that take place?
It would take place at the beginning of my shift. And then if I took enforcement action during that shift, I would also do at the end of my shift. So every shift.
Okay. And when you say enforcement action, could you please describe to the court what that entails?
If I stopped a vehicle for speeding.
Okay. Suppose that you conducted the testing on the radar and it wasn't working properly. What would happen then?
I would take it out of service and we would attempt to get it fixed through Stalker.
Okay. So when you say take it out of service, would you would you continue using the Stalker radar for any reason?
No.
Okay. On August 22nd, 2023, at approximately 3:35 p.m., can you confirm that the Stalker radar was working properly?
Yes.
And how do you know that?
Because I had tested it that day at the beginning and end of my shift.
Can you confirm that the Nissan was specifically clocked by the Stalker radar?
It was the only vehicle at the time that I was actually checking.
Okay. Where you were at on US 400, what is the posted speed?
65.
And what speed did the Stalker radar measure the Nissan driving at?
81 miles per hour.
Okay. Did you ever successfully conduct a traffic stop on the Nissan?
I did.
Do you recall where this traffic stop took place?
I believe by the time I caught up to them, it would have been approximately milepost 309.
Okay. And milepost 309, is that still in Butler County?
It is.
Once you conducted the stop, were you able to identify the driver of the Nissan?
Yes, the driver handed me an Oklahoma driver's license that reasonably matched the driver.
Okay. And do you see the driver of the Nissan present in the Zoom conference?
Yes.
Okay. Can you point the driver out and give a brief description for the court?
Denisha Clark is the name on her window, and I believe she's wearing a black tank top. There's a blue background behind her.
Your Honor, let the record reflect that the witness has identified the defendant.
The record shall so reflect.
Were you ever able to speak to the defendant personally?
Yes.
Did you discuss the defendant speeding?
Yes.
And do you recall how the defendant responded?
According to my notes, she said something to the effect of not realizing she was going that fast.
Okay. And did you ultimately write the defendant a citation for speeding?
Yes.
Barring and a redirect, no further questions.
Okay, Miss Clark Kanaji, at this time, you can ask the officer questions about what he just testified to. It's not your time to make your statement, but if you have questions about what he said, this is your time to ask them, and he is still under oath.
Okay, thank you. Officer, was it video present? Was your camera on or your vehicle camera on? Was it present? Like,
Okay, let him answer the question. Did you have a camera?
Yes, we have an in-car camera. However, we have a retention policy for speeding citations or speeding videos that we tag that way. And because I didn't get the subpoena for this until June of this year, I didn't know I needed to save it. And so it's been purged from our system. I don't have access to it anymore.
how will we know if you actually asked for a driver license?
I asked for it on every traffic stop.
Well, but how would we know? Because that's what you're saying, but
Objection,
All
Your
right,
Honor,
you're
argumentative.
Yeah, you're arguing with him. You've asked your question, he's answered it, but you can't sit there and argue back and forth.
No. I do apologize. I was not trying to argue.
That's all right, go ahead. So you've asked him if he had a video, you've asked him about the driver's license. Any other questions?
So is it any documentation that says that you actually did, or is it just your notes that says that you asked for a physical driver license?
Like I said, I asked for that on every traffic stop. And if you didn't have a driver's license with you, I would have issued a citation for not having a driver's license in possession.
Approximately how old was this person that you stopped at that day?
According to the driver's license information, approximately 40.
How old do they appeared in person?
Objection, Your Honor, relevance.
I'd say it's very relevant since she's saying it wasn't her, and she's questioning the license. Overruled.
Like I mentioned earlier, the driver's license that was handed to me reasonably matched the person that I was interacting with.
You say reasonably matched. How was that person's hair on that day?
I don't recall.
Did you ask about the hair?
Yes, ma'am.
Okay.
And that person did not look younger than 43.
No, not to what I could tell.
Did that person have any gray hair?
I don't recall.
Okay. Did that person have a ponytail?
I don't recall the hairstyle or anything about her hair.
So approximately, well, that's not in question. And it wasn't a paper copy of a driver license, or that person just didn't give you a telephone, I mean, not a telephone, but a name. It was a physical driver license.
Correct.
Do you mind if I ask you what color of the background on the driver license was it?
I don't recall, but typically Oklahoma driver's licenses are either yellow or red. The red ones are, I believe, usually the IDs rather than a driver's license.
Do you recall which color was it?
I don't recall. I would imagine it was probably the yellow one since it wasn't, I don't have any notes or anything or citations for it being suspended or not being a driver's license.
Was it a Oklahoma Real ID?
I don't recall.
But you put in your notes that it was a driver license, but you don't recall if it was the red, the beige, or even the blue, because at that time they was going through the real
Objection,
ID.
Your Honor, testifying on cross.
Sustained. You can't do that.
So you don't recall if it was the red background, the blue background, or the beige background. It was just ID.
I don't recall. All I have is the driver's license number on my citation. I don't know which color it would have been.
Do you know if Oklahoma has the same driver license as their ID numbers?
I'm sorry, what was the first part of your question?
Do you know if Oklahoma, their cards, ID cards, is the same number as that ID card, and their driver license? Is that the same number?
I don't know how Oklahoma does all of that.
Did you ask that person to step out the vehicle?
No,
Did you ask for insurance?
I would have asked for insurance, yes.
Did that person give you insurance?
I don't recall. Believe this was also in, no, it was a Kansas license plate. So I assume they handed me insurance then. If not, then I probably checked on the registration to see if it showed up on there. And if it did, I didn't issue it. If it, let me put it this way, if no proof of insurance had been provided to me, I would have issued a citation for no proof of insurance. And I don't have that on here.
But you don't recall them giving you insurance?
Objection, relevance. This is a speeding trial.
Well,
The reason why is because.
Objection.
I'm going to overrule the objection. You can pursue it. In other words, you can pursue your question.
Yeah, I'm just trying to tie it together because.
Okay. I'll give you time to think. That's fair. Reasonable.
So in your records, you put down, they personally gave you an ID.
In my notes, it doesn't say that.
Okay.
The only notes I have on my citation are related to the speed. However, I have a driver's license information on here, and if I had not received a driver's license, I would have issued a citation for no driver's license in possession.
So in your records, their insurance came back as the same person.
All I know for the insurance purposes, like I said, are if I had not been provided any proof of insurance whatsoever, then I would have issued a citation for no proof of insurance as well. And since that's not on here, I'm assuming I was provided proof of insurance.
Can you make a mistake with the people?
Sure, anybody can make a mistake.
Have you ever been given a false documentation?
No, I've not.
Can you explain what you mean by giving false documentation, Miss?
That person who gave him the information was not the right person.
And is that the question you answered, Trooper?
Yes, to my knowledge, I have never been handed a fake driver's license or something to that effect.
but you don't recall them giving you a piece of paper.
Objection, Your Honor, asked and answered.
Sustained.
I just want to make it clear,
Your Honor,
Well, let her state what her point is.
because this trial is about it's the wrong person. And I just want to make it clear that
Well, are you asking a new question or just repeating one of the other ones?
just making it clear, Judge, I'm sorry.
Your Honor, asked and answered and testifying on cross.
All right, we'll sustain that and move along.
On the registry, what was the name?
I don't recall off the top of my head. I can look it up real quick if you'd like me to, Judge.
Well, if you need to refresh your memory, you may look at what documents you have to do so.
Is it the same documents that's gonna
Let
pull
him
up?
look and refresh his memory if he can.
It looks like, Judge, if you're all right with me giving the registered owner's name on this, I will.
The registered owner?
Correct, of the vehicle as it appears now. I don't recall if this is what it showed at
Oh,
the time.
Your Honor, the state would request a ruling as to whether that is relevant for purposes of today's proceedings.
okay. Do I understand, officer, you're trying to refresh your recollection of who the registered vehicle was on August 22nd, 23, and you don't have independent recollection, but by looking at who the registration records are today, you can do that. Is that correct?
Correct.
And your objection to that is what, Mr. Regier?
Your Honor, relevance on the grounds that that information concerning who the registered vehicle owner is now may not accurately reflect who the registered owner was at the time of August 22nd, 2023.
Well, that is a valid point, but at the same time, the defendant is saying she wasn't driving the vehicle. If she hears the name of who the vehicle belongs to, she might help figure out who that person is, if she knew him, or I think that it is relevant. So in that regard, I'm going to overrule it, but I'm not sure I want the registered name on YouTube. Can we go off of YouTube for about just a couple seconds, Missy?
Yes, we can. It'll take me a few minutes to get back on, but yeah, we can.
Is there some way he could send?
All right, folks, and that was it on that one. I did go on the court records and I did check to see. Normally they update them and they would put the punishment on there. It looks like it got passed. It looks like they're going to give it another date and they just haven't updated it. But that was it. I've got a funny politics story without mentioning politics. When I started YouTube, I wanted to do a politics channel. It was 2024 and I knew the election was coming up. And I I left that within a few weeks. That was the most miserable experience. About 2 weeks was just miserable. The hate, the comments, how mean things were on there. So I am all for it, Nan. When you say no politics, I love politics. I love my country, but politics is not the best place on YouTube. It's a nasty place for people on there. I wouldn't have imagined it. I wouldn't have imagined some of the things I saw on there, and I take some of these videos serious. I like putting out the videos, and I like doing them, and I hate when people are being mean to the defendants just to be mean. I hate whenever things are just nasty just for the sake of being nasty. We're better than that as a people, and we can just do that. We can be better than being nasty with people. I like the court thing because in the end it affects all of our lives, and I think we know someone who's been in the court system, or we know when the court system has failed us or it has protected us. So if you've been in a car accident and you had to fight for that insurance money, sometimes sometimes the court system, helps you pay your medical bills for the rest of your life. But definitely no politics. I see whatever you're saying, no politics, but you love football. I don't watch a lot of football. I used to like politics, and we're not going to get into it here, but it's a horrible, divisive thing with our country, and religion is so personal. It's hard not to be dismissive. The other day when we had that Muslim lady wrapped up in yellow, wonderful, KS, they dismissed it. Okay, wonderful. In the end, sometimes it's a tactic to wait out a trial long enough because that body camera footage doesn't last long. They reset that stuff, and so if you can make a case last so many months, you can definitely wait out. You can definitely wait out the body camera. So if you ever do something stupid and it gets caught on body camera, just drag it out for 6 months to a year, and you should be good. But anyways, we're gonna get back to it. I got a neat magistrate one. It was an interesting one. You see people that can't make it to court, and this guy was such a upright person. He made it from the hospital bed. So I'm gonna throw it up for you.
Yes, you're on. I'm being told by the criminal department in the back that the officer from the hospital is in the waiting room for Mr. King.
Okay.
Thank you.
I have no problem. Thank you.
Thank you.
Gentleman in the white shirt. That's you. Gentleman
yes,
at
ma'am.
EDC in the white shirt. What's your name, sir?
Anthony Ziegler.
Mr. Ziegler, this magistrate in charge here on criminal matter, case number 24045800001, sir. You have an attorney, and it's Anthony Taiwan Ziegler, sir?
Yes, ma'am.
Okay. Counsel Reagan, you're representing Mr. Ziegler?
Yes, sir. Right on behalf of Mr. Anthony Ziegler, waive the formal reading stamp duty. He's been advised of his rights, sir.
Thank you. I'm gonna enter plea of not guilty. Court date is September 18, 2024. Pre-trial in front of Judge Bryant. Mr. Ziegler, while this case is pending, you are not to have contact with North Keith Smith. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Further, you're not to possess any firearms or any other dangerous weapons. And further, you're not to go back to the residence on Toll Bridge while this case is pending. Do you understand those bond conditions, sir?
Yes, ma'am.
Okay. All right, Counsel Ragland, go ahead, ask the bond, please.
Yeah, if you were asking for a $50,000 cash bond, you'd be able to post bond. We're asking for home arrest at a different location. Very assaultive matter, Your Honor. The complaining witness buys groceries for his mother. He goes over to the area, the house where she lives. I'm not sure if this is a boarding house or what, but this defendant opened the door, started making threats towards the complaining witness, and he said, "Let's go." And with that, he started punching him in the face, and the complaining witness said at least 10 times, pushed him off onto a bench and off the porch, I believe. Shoulder and dislocated shoulder from the incident. The officers, when they arrived, they observed that he left side of his face along the cheek was swollen. Upper and lower lip were swollen and bleeding from multiple locations. His right shoulder appeared to be noticeably lower than the left, and it caused him, the complaining witness, pain when he tried to move that. The defendant is current.
Hey, April, I hate to call you out on it, but he is not the stop talking about your case guy. Stop talking about your case guy is down in Florida, down in Panama City, and this is up in Detroit. They certainly look like they could be twins, though. I thought it was at first, but I didn't catch the accent with this guy. But I'm from the Panama City area, and so the stop talking about your case guy, that sounds like everybody you see at the store around where I grew up at. So we're going to jump back in it.
Federal probation supervised release, Your Honor. Per lien, Mr. Ziegler also has access to drugs or weapons. He's a convicted felon with prior assault to do great bodily harm, less than murder, felony weapons, possession by a felon of a firearm out of the 6th Circuit, and felony CCW out of the 8th Circuit. He's got an extensive record, assaultive record. There's never a reason to assault someone like this, Your Honor. Problem may be, but there didn't seem to be a problem except for this man bringing groceries over to his mother. He is an extreme danger, Your Honor. He's got a violent history. And we're asking for the $50,000 cash surety with tether home arrest. Thank you.
Got a question.
Yes.
The prior convictions, is that from 1998?
Well, there's one of them from 1998, but there's a number of them prior to that. And he's also on federal supervised release now. So I believe
He's on federal. What is the charge on the federal case?
You know, Your Honor,
Conviction.
I couldn't find it. Sorry.
Okay. So I see 2006 looks like out of 6th Circuit, Oakland County, 8th Circuit Court, CCW. Council Reagan, go ahead.
So obviously, you know, we know that my client has some prior history, but it's in the past, Judge. He's working every day, got a child on the way, he's living with his wife. Judge, you know, obviously the way this is written, it's not written, you know, quite like it actually happened. So, you know, I don't want the court to read this and say this is actually what happened. This is one side of the story. Now, we know it's going to be a lot more to it. He's being supervised right now, Judge, as Mr. Ragnar says, on federal probation. He has a tether, Judge. What's
the probation? What is the conviction?
It's a RICO situation, Your Honor. So it's
RICO
not
situation. Is that
it's
involving any type of assaultive behavior, Council Reagan?
No, not to my knowledge at all, Judge. You know.
Okay.
So he's on tether for that, Judge, and you know he's being monitored. So you know, Judge is working every day. He's being monitored by his federal probation officer. He's supporting his family. We have one side of the story, Judge. He's not going anywhere. It's not a flight risk. He's not going to go back near this person on Trowbridge. He's staying somewhere else. He's going to go do that. So I'm asking the court, Judge, I don't think a cash bond is necessary, only because I think the monitorization of the federal case lets us know exactly where he is at all times. So I'm asking for the personal bond, Judge, and the no contact provision with this complaining witness. Obviously, these are allegations. There's more to it than actually what is being stated in this complaint, Judge.
Thank you. And court has heard the representations on both sides. Council Ragnan, unless you have something new to tell me.
I was just going to tell you about the search warrant, the rifle and other ammunition.
You don't need to tell me, Council. Like I said, if it was anything new, I can read that there was a search warrant done. There was items dealing with firearms. And the thing is that even if he's not on probation, RICO matter or not, until he acquires his rights to possess firearms or ammunition, he's not allowed to be around them, possess them, purchase them, sell them. And it's kind of hard that somebody did not. No, kind of hard that somebody did not. Council Reagan, court is talking. Thank you.
I'm sorry, Judge. I apologize.
I apologize. All right, kind of hard that I know that the investigative report can be one-sided, but it can also be both-sided information from both sides. But what this court is concerned is that the complainant suffered some injuries, okay? And while it's rare about somebody hurting themselves, it doesn't appear that this is that situation. So somebody got injured. There was injuries in this matter. So even if Mr. Ziegler was on or is on, okay, some sort of the tether, and that's what he's on, correct, Counsel Reagan?
Correct, Judge. Correct.
So the tether doesn't change. It doesn't prevent him from committing or allegedly committing offenses. Okay, and that's the allegation. So he's on probation, he's on tether, he's accused of committing, in this case, a aggravated assault. And it's not enough that somebody allegedly is slapped or anything, but there are some serious injuries where, like either a dislocated or a broken shoulder. So let's see, anything else? And the assaultive, that is from 2006. He may have been placed on probation. He may have been incarcerated. I don't know. But assault with intent to do great bodily harm, less than murder. Okay. Court uses clear and convincing evidence standard. Okay. In terms of when it's entertaining a monetary bond. And then even in this matter, this court does believe that Mr. Ziegler, he is a danger, not only to the complainant, but to the community. He's going to have a cash surety bond of $10,000. I'm not going to put him on a tether. I don't think that's going to help. But with that being said, counsel, this is an unaffordable bond.
Yeah, Judge, we just like a bond redetermination here, correct?
Okay, no problem. That means, Mr. Ziegler, it's this Friday, August 16, 2024. You're going to go in front of either Judge McConigal or Judge Williams, who's going to look at the bond amount and bond conditions. Do you understand that, sir?
No, ma'am.
Hey, so Mr. Ziegler, since you don't understand that, let me say this again, okay? Court date is September 18th. That's a pretrial in front of Judge Bryant. Your bond is right now $10,000 cash surety. It's my understanding it's unaffordable. So that means you're going to get another court date this Friday in front of Judge McConigal or Judge Williams, who will look at the bond amount and bond conditions. If they think that it should be changed, they will change them. Do you understand that part?
Yeah, but this is on the record.
Everything is on the record, and just so you understand, Mr. Ziegler, because everything is on the record, I will caution you as to what you're going to say that you could incriminate yourself regarding this case. Your attorney, you have a great attorney, Counsel Reagan, and so you will get another shot at the bond amount and bond conditions. Do you understand that?
So I can't put nothing on the record?
You can, but your attorney, Counsel Reagan, will probably caution you not to say anything in reference to the alleged facts.
You want to talk about your heritage? What exactly do you want to say?
There you go.
He's a Native American. Mr. Ziegler identifies as a Native American judge, and we just want to make that part of the record. He is a Native American.
Okay.
Yeah, as a Chickasaw and Choctaw Nation, and the Cherokee, we have our own constitution and our laws and bylaws. I just want them to be adhered to or a part of this hearing, further hearing, so that way I can be, judged accordingly and not according to, the United States Constitution, which says that, a sound-minded body a Caucasian of 21 years or older as citizens. I don't go by that Constitution. I go by my Chickasaw and Choctaw and Cherokee Constitution. I just want to let that be known. I'm Cherokee by blood. I can prove it. I'm not African. I'm not none of that. So I just want to put that on the record. So when I get treated fair, I just want to get treated fair. That's all. I don't want this to be like history. No,
Thank you, Mr. Ziegler. Everything is placed on the record. Thank you, and your attorney will bring it up on Friday also. Good luck. You can step aside. DDC, I'm gonna hopefully do a hospital arraignment. Detective White, are you here? If Detective White, if you're here, can you unmute? Detective White. The gentleman at EDC, please stay silent. Yes. 0901, you have an attorney. Go ahead, counsel. All right, Counsel Vincent, are you here?
Yeah, Mr.
Didn't know who it was when I saw Hotmail.
Yes, ma'am.
Okay, all right. We have the gentleman at a hospital that has a blue cap on his head. What's your name, sir?
Billy Gerard King.
Thank you, Mr. King. I'm Magistrate Chartea. The case number is 2405-880901. You have an attorney. Go ahead, counsel.
Now, right on behalf of Mr. King, waive the formal reading, stand mute. He has been advised of his rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are August 23rd, 2024. Probable cause conference followed by preliminary examination, August 29, 2024. Both matters are in front of Judge Giles. Mr. King, while this case is pending, there is no assaultive or combative behavior on your part. Do you understand that, sir?
Correct. Yeah.
Okay. All right. Counsel Vincent, are you here on behalf of the people?
I am. Thank you, Magistrate. Steve Vincent, P 71917.
Go ahead, sir.
Oh, thank you. We're going to be asking for 20,000, 10%. We're also going to be asking for a tether as well as a curfew. Just to highlight the particulars here, Judge, and this particular incident just happened a couple of days ago. Police called, the defendant's ID'd as the offender here. They attempt to try to arrest him. He runs away, tries to jump over a cement wall or something. And then he does it unsuccessfully, allegedly breaks his ankle. I think that's why he's in the hospital right now. And then he continues to continues to resist, I'm sorry. And the police have to tase him. Now, that probably to you, Magistrate, wouldn't constitute the cash bond that I'm requesting. But here's the thing. He's got two other cases going on, one of which is going to be going up for redetermination tomorrow based on a capias off of a bench warrant that was continued yesterday in front of the chief magistrate. And that has to do with, I believe it's an assault charge. It's an A and B that stems back from December of 23. He's got multiple failures to appear in that.
What's the bond on that?
I believe that's $500 cash or surety, and that's going to be heard in front of, if Judge Williams is taking the bench tomorrow, in front of Judge Williams for redetermination.
It's a malicious.
He has another pending case?
I'm sorry, Magistrate.
Okay, you said pending cases. So one is assault and battery from December 2023, $500 cash surety. Is there another pending case?
There is, yeah. He was arraigned yesterday as well for an offense date of May 23rd of 24 for a felonious assault. And allegedly, this incident occurred at a gas station where this defendant ended up taking some type of object and tried to assault a patron over at the gas station. All because allegedly that patron had asked him if he was good.
What's the bond on that?
On that one, he was given a $25,000 personal with a tether. So, Judge, if we look at, the totality of things here, this case in combination with the other cases that are going on, I mean, it's the people's position that, you know, he's a danger. He's got multiple assaultive cases. He resisted arrest here, goes so far as to, you know, breaking his ankle trying to get away from police officers. And then, you know, we have the flight and then we have the dangerous component of it too. I mean, flight, previous capiases and all that. So respectfully, Judge, we're going to be asking for that 20,000, 10% tether curfew.
Council Reagan, go ahead.
Judge, I think the A and B case may be an MDP case. The misdemeanor is a $500 cash bond from a few years ago. But regardless, Judge, that's a cash bond that was continued, as Mr. Vincent said, for tomorrow determination. He had the 20,000 personal with the tether already from the FA yesterday. So this bond I'm asking for 20,000 personal, Judge. I don't think he needs two tethers. I think that my client, you know, I don't know the circumstances when if he jumped the gate, broke his ankle. I know it's probably pretty painful. I don't know how his reaction was, if he was squirming, if he was, I don't know what happened exactly, Your Honor, but I think that it's a situation where I think you could give a personal in that case. Just he doesn't want to have contact with the police. I think we're looking at this from a case-by-case standpoint. He's an RNO, I'm asking for personal.
So just a question for Council Vincent. In this case, was there any assaultive behavior against any of the officers?
In this case, we would be emphasizing the flight. I don't think that, and trust me, if he would have been assaultive against a police officer, I probably would ask for 10 times as much. This has to do with flight, Judge. I mean, you know, he's trying to get away from police. He's skipping cases, and that is an A and B case. I have the case number. So
we got a misdemeanor, $500 cash surety going to bond redetermination. We have a felonious assault, $25,000 personal bond, GPS tether that is not going to a bond redetermination. Am I correct?
Correct. You are absolutely accurate. Yes, Judge.
Anything else new that I need to know, Council Vincent?
I don't know. Let me check my notes. I got a full page worth of stuff here. No, I think I covered it, Magistrate.
Thank you. Court uses clear and convincing evidence standard when it's entertaining a monetary bond. We start off with a personal bond basis. In this matter, nothing to indicate, yes, he's running away from the police. Nothing to indicate that there was any assaultive behavior. Yes, running away because he had at the time, it appears there was a warrant out for his arrest. One is misdemeanor, the other one is felonious assault, felony. On the felony, personal bond, misdemeanor, he's got $500 cash surety, and that one was a failure to appear. Is that correct, Council Vincent?
Yeah, I think it was either the second or third time he failed to appear. He had forfeited either one or two previous bonds that he posted, but yes, Judge.
DDC? Oh, no, it's not a DDC, this is a hospital. Detective White?
Yes, ma'am.
Can you tell me, does he have a tether on him?
No, ma'am. Wait, let me check. I gotta feel your ankle.
Oh, no, Magistrate. He was given the tether yesterday. I'm sorry.
Oh, he was given tether yesterday? All right, so I'm not gonna go with that. I'm gonna give him a $50,000 personal bond. Okay, I'm gonna let the judge, whether Judge McConicle or Judge Williams, deal with the misdemeanor matter. I will say this to you, Mr. King, you violate in this case, come in front of this court, bring your toothbrush, because you're gonna be looking at a high monetary bond. Do you understand that, sir?
Yes, indeed.
All right. That concludes the arraignment of Mr. King.
Magistrate, I hate to do this to you. Could you just repeat the dates on that? I'm sorry.
Sure, August 23rd, August 29th.
Thank you.
You got the 23rd there, but I don't know what that was for.
That is funny. Hey, everybody, I found a way to get the comments up. All you gotta do is just start talking into nothing and the comments go wonderful. That's funny. That made my day right there. Thank you all for mentioning that. All right, how about now? Okay. All right, everybody. The case earlier got dismissed with the lady with a million words. That was funny. That she got to do all that talking and then ended up getting it dismissed. So in the end, it did work for her. Thank you guys for coming out to the stream. Absolutely. Micah Psycho saying you can't hear me. That's it. I could hear me just fine in my headphones. I guess that's what matters, right? I got to get it fixed up. Somehow I got this set up to where if the camera comes on, the volume turns on, and so I end up muting it myself, trying to fix the technology. And so the technology is certainly smarter than me. So, all right, you guys have a good night, and thank you so much for coming out. If you have a judge that you want to see, okay, I'm gonna have to go because it's still saying muted and it's telling me that it's running. So, anyways, you guys have a great night, and we'll see y'all tomorrow.